Magistrates Court video, Magistrates Court Process, Part 2. So I defined briefly the reasons why I need to make this video in the introduction. I have to say two things. First, sorry to the people that have already had to go through the Magistrates Court system and defend themselves without this knowledge and understanding. I only found this on the day of Daniel's last hearing when Phil placed this into my hands and allowed me to take it with me. And as I say, my understanding of these things has been incremental, from an understanding of research on the internet to actually then being and seeing what was happening on the field in real time, and then to being in the courtroom situation both next to Daniel and then in front of the magistrate myself. My process has gone, my understanding has gone through about 4 layers of depth. And the last layer was this is the 4th layer of understanding that it gave me. I'm working on a 5th layer at the moment. Anyway, I'm not here to talk about myself. I need to share this information and put it out there for the people who need to hear it, and I'm sorry for the people who've already had to deal with these motherfuckers without this information being readily available to them. And I also at this point wish to acknowledge certain errata in previous videos, especially dates. I tend to get dates fucked up all the time, and I apologise for that if I've said, watch some of the things that I say the dates of, because sometimes things get transposed in my head. I've got so much shit still rattling around in there, it's insane. And to try and keep track of it, because just about all of my presentations are ad lib, so I don't have notes to follow, which is a real pain in the arse in that way. But I try to speak as honestly and as openly and from the heart as I can whenever I speak. And that's the benefit of speaking ad lib as well, is you're not following a script as such. But notes are necessary, especially if you're going to deal with these people, man. You need to have a structured defence, or a structured way in which you wish to try and cut across their process. So, having researched Black's Law Dictionary 6th edition, I came to an understanding a little while ago that my defence needed to be structured around 2 legal terms. One was failure to follow due process, and the other one was conflict of interest. And I believe that I could prove both of those things, and that initially were going to be my main points, because in my defence that I would try to prove those points. I would try to show and demonstrate both conflict of interest and failure to follow due process. Right. And this is how useful this current dictionary is. This is the Nexus Lexis Concise Australian Legal Dictionary 4th edition. Phil picked this up second hand. You can download it off PDF drive at the moment if you want the PDF version. He was actually looking for the Butterworth's 3rd edition, which he had to end up ordering from America because he couldn't find one in Australia, and that's the Butterworth's 3rd edition concise Dictionary of Australian Law. This is the concise Australian Legal Dictionary. And they changed. This is very, very streamlined, very much up with the way that the system is processing individuals in this very current hour. And you'll see what I mean when I start to read out the definitions and explain to you the way that this process works. So this is actually skipping ahead in my understanding. I've done more research on the Magistrates Court, etc., to understand their process even between my 3rd and 4th hearing, which I haven't shared any of that information with you yet. And I'm sorry about that. I meant to do a presentation of my 4th hearing and what transpired therein, but I still haven't got to it because I'm still... I'm basically still gathering all of my resources and information together and going over it all that I gathered prior to that 4th, because I did a lot of intense study. I did a week of intense study. It actually felt like I was studying for my bloody Year 12 exam entry, university entry score. It was insane. On about the 3rd or 4th day, I was getting a headache from it, just from the sheer amount of brain power that was having to be expended. Yeah, like a fucking band as you're crunching the cogs. Yeah. So this was a real blessing to get this, because it took me into a deeper layer of understanding. And what I will actually show, for the benefit of the people who are dealing with these people, the Magistrates Court, Supreme Court, etc., current legal system, is their process and how to actually structure your case. So actually how to structure your case and the points that you need to prove in order to trigger a positive response in your favour from their process, right? So when I looked up due process in this dictionary, it referred me to abusive process, and I think conflict of interest also referred me to abuse of power, which is actually, the entry under that is really interesting in reference to the nature of the magistrate's discretionary judgment. But abusive power, abusive process actually gives you an outline that you can use to, it actually gives you the main points that you need to prove in your defence that will substantiate a verdict in your favour according to their system of judgment, process of judgment. And this is so this is under abuse of power. This isn't where I was going to start. I was actually going to start back with summary judgment, so you understand the nature of the judgment that you're dealing with. Summary jurisdiction, summary offences, that's where you need to start your research, is to understand that summary conviction, etc. The summary court, see what a summary court is. So I need to go further back in my research to show you what a summary court is, because that's in the Black's Law Dictionary definition, and that shows you why these people are operating using the process that they do, and how they've taken a previous process that was attached to the common law system under jurisprudence that was adjudicated and administered by the Supreme Court. They've actually extended that process's power and corporatised it as a private entity to process people and to make a determination, and not just a determination, but to also administer a sentence or a conviction. Now, they never had that power. The original summary court, it was never meant as that. It was only a preliminary court, and it still retains most of that character and identity even in its current form as a preliminary court because its power of committal procedure. You need to look that up, the power of committal procedure, right? The committal process is the actual term that you need to research on their website and in their legislation. And in Law Dictionary, the Magistrates Court committal process was their initial function as a preliminary tribunal to establish whether the case had grounds to be tried, to go to the Supreme Court and go through the expense and the rigmarole of trying the individual by their lawful right under indictable offences that can actually, where the penalty actually affects the direct well-being, happiness, prosperity, freedom, liberty, commercial conduct, etc., of the natural person, the living, breathing man, the living soul, right? So and that's what we call crime, right? If it's that bad that it's actually affected another person and created a victim where their living, breathing person, their living soul has been affected by your actions, that is fucking crime. Right? That's very clear in the law, what crime is and what crime isn't. And that's what they call indictable offences. Summary offences, I mean, listen to this. You want a vague definition, right? You want something to actually stretch the boundaries of what you can do inside that courtroom. Listen to what a summary offence is defined as in this. And this is the dictionary that they follow even more than Butterworth's. Summary offence. An offence not punishable on indictment. So even if they indict you for it, it's not punishable on indictment. So it's not serious enough to actually be, even if they can indict you for it, it's not serious enough to punish you on an indictable level, right? Or indicatable offences that may be tried summarily as distinct, that was the next definition. An offence not punishable on indictment or for which no procedure is specified. Interpretation Act 1987, New South Wales, Section 21. Also see indictable offence summary proceedings. Summary proceedings change the perspective on that a little bit, but the actual definition of a summary offence is quite loose, to say the least. And it is not an indictable offence, it's not a crime, right? And that's the point I was making, the difference between that, the effect, an indictable offence actually affects a living person, right? And the punishment of that offence affects a living person. Hence the necessity under the law of England, the law of the Holy Bible, right? The King James Bible, which is part of the law of England and the common law. A lot of the judgments come straight out of that book. A lot of the way we deal with each other comes straight out of that book, man. The more you read that book, New and Old Testament, the more you will actually see how relevant that is still to this very hour. And I'm not talking about new Bibles, the old King James Bible, man. You'll be able to understand, you spend any amount of time in that book and you will be able to understand what it is saying to you. Have no fear of that. The authorised version 1611, not the new Kingy Jimmy, right? Which fucks around with the sentence structures and even changes some of the verses to deny the deity of the Holy Spirit in one place, I believe. That Bible, the sentence structures even are important because they will actually help you. The way that Bible is written and put together shows a profound understanding of the way the human mind learns. And even without a dictionary, you can understand that old English Bible, that old archaic Bible. You can understand it better and clearer than a lot of this stuff, right? Fucking oath. Like if I just read through this shit without explaining it to you, you'd probably miss half of what's in here. I shit you not, because I have to read it over and over again myself to get the proper understanding of how they even, the terminology and the way they couch their phrasing and the words that they use. Words are significant, especially in the law, mate. Words are significant in the holy law too, the word of God. It's all spiritual. Words are spiritual. They come out via pneuma, the breath of life. Where did that come from? According to the Holy Bible, when God created man, he breathed into his nostrils and man became a living soul. Our words are spiritual. Our breath is directly connected with our spirit, our core life force and core archetypical personality and core understanding of the natural law that God created us with, the light of conscience, the light of understanding, the light of the knowledge of himself, so that we know the true God, even though we justify it and deny it to ourselves, so we can justify our own disobedience and sin, breaking God's spiritual law, not just the law of man, right? We still know in our core the truth. God put it inside every one of us, man. It's there. You can no more divorce that from your nature than you can take away your own life from yourself. That's how tightly bound that is to your intrinsic identity, that level of understanding. And it's what they call natural law, which is the foundation of common law. I can read you some really interesting stuff about that. So, I will start at abusive process, because that is actually a main point that you can argue, and that was what I was going. That was one of my points that I thought. Right, these are things that you have to prove, though. If you call this and you want to take this as your line of argument and your line of reasoning and part of your line of defence, you need to be able to prove these things. So then these things become your main subheadings or your main points that you want to prove under abusive process, failure to follow due process, and even in some cases, an obvious conflict of interest. So read those definitions of those terms in the Black's Law Dictionary and then understand these definitions here. So abusive process. 1, instituting or maintaining civil or criminal proceedings that will clearly fail. Proceedings unjustifiably oppressive or vexatious in relation to the defendant. So you need to prove one of these points. And generally, any process that gives rise to unfairness. Walter and Gardner, 1993, 177 CLR 378, semicolon 112 ALR 289. Bastiotis versus Roads and Traffic Authority of New South Wales, 2006. 226 CLR 256 semicolon 227 ALR 429 2006 HCA 27. So these are the case law precedents, where to find these precedents, why they give that in the definition. This is their justification for the definition that they've just given you, right? Of which, so it is any general proceeding that gives rise to unfairness, or which, this is the 4th point, or which may result in a diminution in public confidence in the court, such that the court should refuse to hear the proceedings by staying the proceedings before the court, either permanently or temporarily. Also C, and then it gives the case references for that. So these, to reiterate, and then I'll close and I'll make another video. To reiterate, to prove, these are the main points that you then need to prove if you're going to prove that the court has been acting in abuse of process, right? So the first thing you need to prove is that they are instituting or maintaining a civil or criminal proceeding that will clearly fail. Hence, they want you to plead guilty on everything, right? Because then you've absolved them of that abusive process. Because if they actually believe that their proceeding will fail under the actual initial authority and power, jurisdiction that the Supreme Court granted the preliminary court of the summary court jurisdiction, they are supposed to dismiss the fucking case. And you see it even goes down to the point where they come to a point where they have to concede that they put either a temporary or permanent stay on the case because they cannot deal with the subject matter, right, with the case before them, because it would reduce public confidence in the court if they were to address the case before them. That's the fourth point. You see what I'm saying here? Right? You see why this is so important? So you have to prove that they are instituting or maintaining against yourself, right, a civil or criminal proceeding that will clearly fail, and that they believed. I guess you have to show that on some level they would have had to know that it would fail, and in which case they should have summarily dismissed it. But they won't, because they're being given power of determination and they're being given power of prosecution and committal, right, by legislation. That was not their initial power. If they believed that you were guilty, they were supposed to then use what they now call, what did I say it was before? Committal process, committal proceeding. So now the committal proceeding, instead of what they used to do, what their jurisdiction was to do, what the summary court's jurisdiction was under the American legal system that they've borrowed this whole structure and process from. You can see it clearly, right? If you bother to go and research and look. They borrowed it straight out of the Supreme Court jurisprudence, grand jury system of American justice, right? Which is an interpretation of the Westminster common law jurisprudence system of justice. And we operate under the law of England at this point, which is part of the law, is the underlying law of the Commonwealth, which we are still under, even though these people don't do everything they can to try and deny it. So you have to prove that it will clearly fail. What they're trying to maintain and institute against you will clearly fail, right? And you have to prove that in your defence. The second thing you need to prove in order to approve abuse of power, and this is within their system under their definitions, right? This is why this is so important, because if you're going through their process and their system, these are the things you need to hit, right? These are the things you need to prove that will trigger the appropriate responses within their process. Proceedings unjustifiably oppressive or vexatious in relation to the defendant. So if they are proceeding in a way that you can prove is unjustifiably oppressive to you or vexatious in relation to you, and then you need to go and read the definitions of frivolous and vexatious, and also read the definition that it gives on stay as well. But in this is the second point. So you need to prove that their proceedings are unjustifiably oppressive or vexatious in relation to you personally, in proceeding against you in the very trial that you were in, right? Or as a result of the charges that they are trying to proceed against you with, or even the attitude of the witness, right, that is trying, or even the attitude of the prosecution, or even the attitude of the magistrate could come under being vexatious, depending on how they try to push the thing forward. I would say that Glenn Thiessen's actions were vexatious when he actually tried to continue the trial with Daniel Vincent present in the room, but without him having any actual further part required for him to play in the process. So he was going to actually come to a determination without Daniel Vincent even needing to say another word. In fact, he would have preferred Daniel Vincent to say no further words. That was very clear by the way he treated him, concurrent to that process and the resultant of that process. that statement and the pursuit of that process. And that is their process. That's what they will do. The magistrate even told me if I did not enter a plea, the process would enter a plea automatically of not guilty for me, and then the magistrate and the prosecution and the court clerk would determine the nature of the validity of that charge and whether I was guilty or not and what should become of me as a result of that. All without my necessary input if I refuse to actually participate at that point, without being able to break across their process at that point. So, the third thing you need to be able to prove is generally any process that gives rise to unfairness. So now this is a very general approach, and it's any process. If you can show that the court proceeding gives rise to unfairness or which may result in the diminution in public confidence in the court, such that the court should refuse to hear the proceedings by staying the proceedings before the court either permanently or temporarily. So I believe that's why Daniel's case was forestalled again. Right? Because you have to prove, if you can prove in the process itself during your hearing that the process gives rise to unfairness, generally any process, right, that gives rise to unfairness. So if you can prove what unfairness is, and that which unfairness will result in the diminution in public confidence in the court, such that the court should refuse to hear the proceeding by staying the proceedings. So you have to bring them to that place, right? And that's probably the hardest one to achieve, is to show the unfairness of their process to the point where they themselves determine that they cannot hear the proceeding. They refuse to hear the proceeding and put a stay on the proceedings. Right, so that's the third point that you want to try and hit if you're going to, and that's quite an achievement to do that. If you're going to actually use abuse of process as one of your points in which you wish to directly argue your own defence, you're using their abuse of process in your defence. Right, so second definition is criminal contempt of court through abuse of the court's process. So if you then, this is where the magistrate becomes liable, even under the Magistrates Act. If you can prove criminal contempt by the magistrate through the way he uses by abusing, in abuse of the court's process, the way he uses the court's process in an abusive way towards you, right? Including serious misconduct such as forging or otherwise dishonestly altering process. Well, forging, that's like counterfeiting or fraud. Like forging a seal of authority, like forging an oath of authority. So that comes under criminal contempt of court in abuse of process as its second criminal, under that second definition, second primary definition. And it gives you Finnerty versus Smith, 1865, 1 Bing NC 649, semicolon 131, ER 1267, internationally deceiving the court. intentionally deceiving the court. Now, if you have authority in that court as a living man and they intentionally try to deceive you, then you are part of the court. They are intentionally deceiving the court, so you can use that. If you can prove that, you can use that in your defence, and also to bring them to a place where they have to stay the proceeding, and maybe even bring them to charges of criminal contempt themselves. Or, and it gives the reference for that. Malson versus Official Receiver, 1947, 74 CLR 602 1947 ALR 489. Or the next point, prejudicing other persons through misuse of that process. Prejudicing other persons through misuse of that process. Conflict of interest and prejudicing other persons. So what? Looking after your Freemason buddies in the police, despite the overwhelming weight of evidence that's against them in their conduct toward the people. Is that what you're talking about there? Prejudicing other persons through misuse of that process, or being prejudiced toward freedom fighters and truth warriors simply because they're trying to stand up for the lawful truth of things, right, in this land. Is that that's a form of prejudice, man. And they use their process to inflict their own personal prejudice on the people. If you can prove that, how they've done that to you through their process, through the misuse of their process, you can get them on that too in your defence, or in this case, maybe even in a case of prosecution of criminal contempt of court. Right, so that's all the things that they are the main points that you need to prove if abuse of process, otherwise defined as due process, failure to follow due process, or conflict of interest. That last one, that last definition, prejudicing other persons through misuse of process, is definitely a demonstration of conflict of interest, right, which comes under abuse of power as well. So that's where I'll leave this, and then I'll pick up in the third one. I'm sorry to make this so long, but I had to expound these things. Hopefully you get a clear understanding. Hopefully I haven't muddied things and made it worse. But in the third one, I will actually go through the basic points in any trial that you need to actually hit within their process in order to trigger a win or a point on the scoreboard in your favour.